The topic of this presentation is managing parties with selective mutism in the Sulh Conference of the Sharia Court. Sulh is a form of alternative dispute resolution (ADR) mechanism which is used in a Sharia court. And Sulh is quite similar to mediation, which is practiced in the civil courts. It involves a third-party neutral known as a Sulh officer in the Sharia court and a mediator in the civil courts. The Sulh conference or meeting is hosted and managed by a Sulh officer who will assist the parties in resolving their disputes on a voluntary basis. Thus, there is a three-way communication between the Sulh officer, the first party, and the second party. Selective mutism is an anxiety disorder which is characterized by a failure to communicate in social situations and begins in early childhood. The sufferer of selective mutism might intend to communicate, but in certain situations find that they are not capable of doing so, such as shyness. The problem statement. Recent literature on Sulh does not provide guidance on how the Sulh officer is to deal with a party who suffers from selective mutism. Most of the literatures touch on the disability of parties in a situation where the parties are involved in altercation, the parties fail to attend court, and in such situation, the Sulh conference will have to be cancelled. Even though selective mutism is associated with mutism, not much is known about stated in the current literature on the impact of selective mutism on the ability of a person to communicate effectively during the process of settlement, discussion, especially in the Sulh conference. The main objective of this study is to analyze the barriers faced by a person with mutism in the Sulh process. The sub-objectives are as follows. Firstly, to identify the barriers associated with communication between a normal person and a person with selective mutism. Secondly, to analyze the impact of selective mutism on the Sulh process in the Sulh conference. And lastly, to analyze the possible ways to address barriers in communication between a normal person and a person who suffers from selective mutism in the Sulh conference. Research methodology. This is a conceptual paper which uses a qualitative method through document analysis of relevant library-based materials. Data were obtained from primary and secondary sources. Primary data were obtained from the Al-Quran, relevant statutes, various Sharia court, civil procedure rules, case reports, journals, articles, and court practice directions. Secondary data includes scholarly articles, journals, official websites, and other electronic materials on selective mutism and the practice of Sulh. The findings from the literature analysis shows that effective communication is an essential tool of the Sulh conference. The Sulh conference usually begins with the introduction of the Sulh officer, and it will follow by the opportunity given to the parties to voice their views and to inform the Sulh officer about the version of their disputes. As such, we may find that the Sulh conference involves active communication between the parties. Thus, in such situation, the Sulh officer must take into consideration of each party's ability and disability to communicate effectively in the Sulh conference. The barriers in communication. A party who suffers from selective mutism may demonstrate an inability to communicate effectively during his or her presentation in the Sulh conference. Barriers faced by persons suffering from selective mutism must be addressed with the use of viable methods to ensure that the Sulh settlement process is carried out justifiably, especially in line with the Sulh work manual, irrespective of whether the settlement of the dispute is successful or otherwise. Impact of selective mutism. The party who suffers from selective mutism may not participate accordingly in the Sulh conference, especially during the presentation of the version of his case, caucus sessions, and joint discussion. In these stages, for example, in the presentation of the version of his case, he needs to communicate his version of his case to the parties. His inability to present the version of his case may jeopardize his interest to convey his message to the Sulh officer and also to the other party. The Sulh mechanism is supposed to involve a three-way communication between the Sulh officer, namely the Sulh officer, he himself, and also another party. As such, it is not a two-way communication between the Sulh officer and the party who is not suffering from selective mutism. In such a situation, the Sulh session may not be held properly and may need to be discontinued, for it is one-sided. Inability to communicate effectively due to Sulh mutism retards the making of a valid contract. A valid contract must consist of an offer, acceptance, and also consideration. As such, inability of a party who suffers from selective mutism may mean that he or she may not be able to present his case effectively, and this will affect the essentials of Sulh, which must be in line with the rules applicable to a contract, especially the first rule where there must be an offer and acceptance between the parties. This is further substantiated in the Al-Majal Al-Hakam Al-Adaliyah, which states that Sulh, which defines Sulh as a contract removing a dispute. Adjourning the Sulh conference when one party is unable to convey the message accordingly, or in the absence of the two-way communication, may seem to be the best way if the Sulh officer finds that it will be a one-sided discussion. The Sulh officer should also maintain his composure and act in a polite manner and not harass the personality or person who suffers from selective mutism. In addition to what is mentioned here, other acts which may traumatize the person, the party who suffers from from selective mutism, are such as raising his voice and not allowing him or her to participate actively. The Sulh officer should also attempt to reduce the shyness of the party with selective mutism by putting on a smile and directing his or body language towards the said party. In such, it is best that opportunity must be given to the party who suffers from Sulh mutism to voice his or her problems. In conclusion, it is not easy for the Sulh officer to manage a party who suffers from selective mutism. Any decision made without considering the existence of such disability will invalidate any settlement terms. And any such settlement terms which are made not considering the existence of selective mutism should not be used as agreed terms in the court of law. Thus, efforts must be done by the Sharia courts to determine whether a case should be settled by Sulh or not if one party suffers from selective mutism. Thank you very much for hearing.